Highly anticipated legal development, the Supreme Court is all set and poised to announce its decision on a pivotal matter concerning the immunity of members of parliament, the MPs and the members of legislative assemblies from prosecution in bribery cases. Now, this verdict comes as the apex court revisits a landmark 1998 judgment that granted such immunity, a decision stemming from the JAM bribery scandal that shook the nation. Currently, legislators are protected from criminal prosecution for bribes in connection with their speech and votes in parliament and legislative assemblies. But this is what we're looking at. The Supreme Court has now overruled the 1998 verdict in the PV Narasimha Rao case. Ladies and gentlemen, this is the big breaking that we're tracking for you. At this point in time, the Supreme Court has in fact said and overruled that the 1998 verdict in the PV Narasimha Rao case, it has been overruled. Chief Justice of India, Chandrachud, said that we disagree with the judgment in the PV Narasimha Rao case. The judgment in PV Narasimha Rao case, which grants immunity to legislators for allegedly bribery, for casting a vote or the speeches that they make, has wide ramifications on the legislative processes of the country. That has been overruled. Such a claim for immunity fails. This is coming from the Supreme Court, fails to fulfill to the test whether such immunity is necessary to discharge legislative functions. To speak more on this, joining me here in the studio is my colleague Ashok Bagria. Ashok, a big verdict again. Right this morning, I was thinking to myself that over the last 12 months, coincidental, there are all these big cases that are coming to me when I'm in the studio, or these are actual landmark decisions that is coming under the honorable leadership of the Chief Justice of India, Chandrachud. Today, 1998 verdict in the PV Narasimha Rao case, immunity to lawmakers vis-a-vis their statements and votes inside the parliament or the national assemblies. There was immunity from criminal prosecution that has been overruled.
Well, Kabir, yes. For the last 25 years, there has been a very peculiar situation which has been existing in law as far as immunity of a member of parliament or a member of legislative assembly is concerned when it comes to the allegations of bribery. Now, what had happened in 1998 in the famous JMM bribery case was that there was an anomaly in the judgment. That judgment was delivered by a bench of 5 judges. The 5 judges held that, look, the members of parliament and members of legislative assembly are protected in the sense they enjoy immunity under Article 105 of the Constitution and they cannot be charged for bribery. But now coming to the anomalous part of it, the anomaly that crept in was that on one hand, the Supreme Court 5 judges took a big stand saying that they are protected. However, in the case of Ajit Singh, the same bench, when they were ruling it, they said Ajit Singh is open to prosecution. Now, why was the case of Ajit Singh different from the others? Was that here, Ajit Singh, Janata Dal Ajit, the leader of Janata Dal Ajit Singh, had allegedly taken money to vote in favor of the PV Narsimha Rao government. However, on the day of voting, he absented himself from the parliament. And when the matter came up, the court said that, look, this man entered into a deal with somebody and he was expected to vote in a particular fashion, but he did not do that. So he will be open for prosecution. So now this is the anomaly bit. On a larger principle, they say 105 gives immunity. But when it came to Ajit Singh, they said no immunity because that person had not fulfilled his end of the bargain after taking the bribe.
So where is the bribe complete? When you take the payment or you carry out the deed for which you took that bribe in the first place? The court had to clarify on that front as well.
Yeah, that was one of the biggest questions before this 7-judge bench. Now, for 25 years, this strange peculiarity existed in law. Now, the first thing that was argued before the Supreme Court 7-judge bench earlier last year was that you have to understand the offense of bribery. It is complete the moment a person gives a bribe and the other person accepts it. it has nothing to, the offense of bribery has nothing to do with the fact that the person who took the bribery completed his or her end of the transaction. So that is immaterial. The bribery, the offense of bribery is complete the moment a person gives a bribe and the other person accepts it. Now, this is the position which has been accepted by the 7 judges today, and they said that the offense of bribery is complete the moment the person accepts the bribe. And they have said that the previous position or the law laid down by the 5 judges in 1998 is overruled. The 7 judges have cleared the anomaly which has existed in the law, saying that this particular position, if the 1998 position continues, this will go against the very spirit of the Constitution, which is probity in public life. Then they have also gone on to say that they have clarified the interplay of Articles 105 and 194 as far as immunity is concerned. One very interesting thing, Kabir, I want to bring in here is about this particular case. Now, this is a case of Sita Soren, who used to be at a relevant point in time the MLA of a Jharkhand Legislative Assembly, and like the JMM bribery case, she was also offered money by an independent candidate who was contesting the Rajya Sabha elections to vote in his favor. However, on the day of voting, Sita Soren takes the money, goes into the house, but votes in favor of the candidate which has been footed by her political party. So here was a case where she did not live up to her end of bargain. Okay, a situation
performed the act after taking bribe.
So this she came to the she first went to the High Court saying, please quash this prevention of corruption charges against me because of the PV Narsimha Rao judgment. I stand on the same footing. I don't stand on the same footing as Ajit Singh in the 1998 verdict, and it needs to be revisited. The whole process needs to be revisited. And the Chief Justice of India, while hearing, there was a bench of 7 judges. They have given a unanimous verdict today. And even during on the very first day, on the very first hour of the hearing, the Chief Justice of India agreed and said, yes, there is an anomaly in law which exists and we need to rectify it.
Because there were people who were speaking in favor of immunity for these lawmakers, our own legislators, parliamentarians and members of legislative assemblies from various states. They said votes given in Rajya Sabha polls are distinct from the legislative process voting. So the PV Narasimha Rao case in essence doesn't have any bearing on the Sita Soren case in the first place. I mean, these were one of the arguments that lawyers representing Sita Soren had put forth.
See, the basic argument here is what a legislator does on the floor of the House. Any illegality, they are protected. They have immunity under the Constitution for their actions under Article 105 and 194. So, the basic thrust of the argument is, I have done a part of the act which is outside the House, a part of the act which is within the House.
Okay.
So, the culmination of the act which I was expected to do took place in the House, and I am protected. I am immune. I cannot be prosecuted under the Prevention of Corruption Act. That was the position which was taken. However, common sense, what does common sense say? The commonsensical position here was that somebody gives a bribe, the other person takes it. The offense of bribery is complete. Now here comes in the third angle, whether the purpose for which the bribe was given has been fulfilled or not. The position which has been clarified today by the Supreme Court is that it is immaterial whether you, after taking the bribe, you completed or you did an act that was expected of the bribe taker. That is immaterial. The offense is complete the moment a bribe giver gives a bribe and the bribe taker takes the bribe, and you are a public servant. Now, another very important thing, Kabir, in 1998, was with respect to the position of MPs and MLAs, whether they are public servants and protected under 105. Now that one part of that judgment is very important, which said that under Article 105, the members of Parliament and the members of the Legislative Assembly are public servants. That position has been cleared. But when it comes to immunity, they said they enjoy immunity. However, that MP MLA who does not complete his part of the bargain is not immune. So if I take a bribe and do an illegal action, I am protected. But if I take a bribe and I don't do it, I am not protected. So that was the position which has been
the anomalous position that
which
you're
has
clarifying now.
Yeah.
So basically, the Supreme Court had set out to reconsider 3 prime points. The purpose of Article 194, Clause
105
2
and
105, Clause 2, was to allow legislators to cast their votes without any fears of reprisals. Secondly, the PV Narsimha Rao case and the decision that it ends up protecting bribe takers in the first place who act on the alleged bribe taken. And thirdly, it needs to be decided if the offence is complete when the payment of bribe is being made or when the bribe is acted upon by the legislators. Now, all these 3 points have been clarified. The Supreme Court has overruled that 1998 Narsimha Rao case decision, and now they are not immune from criminal prosecution for considering a bribe. It's so funny, Ashok, because another important and interesting aspect is that Tushar Mehta last year in these given hearings had said that the Prevention of Corruption Act is something that has been missed in the 1998 verdict altogether. I mean, a Prevention of Corruption Act, we have a proper law against it. Why was that overlooked?
See, when the court was called on to decide this question even in 1998, it was asked to decide the interplay between constitutional provisions and a statutory law. The constitutional provisions were 105 and 194, which gave immunity to members of the Parliament and the members of the Legislative Assembly. And on the other hand, was a statutory law which had been enacted by the Parliament, which is called the Prevention of Corruption Act. So they were called on to decide how these 2 provisions, constitutional provisions and statutory provisions, interplay on the ground. And on the basis of that, they interpreted and they said no, 105 and 194, 1 and 2 grants immunity for every action of casting of votes or making a speech. There are 2 things in 105, that you will be protected for casting your vote and for making a speech. So today the court says that look, as far as taking bribe and speaking on the floor of the House, whether Parliament or the state legislature, amounts to violation of the principle of free speech. So after taking money, you are not delivering a free speech. It's a forced speech. So the court says that it goes against the principle of free speech also, and we hold that this kind of an interpretation which the Supreme Court had given in the 1998 verdict has to be revisited, relooked and set aside.
This is what the CGI says. Take a look at this. Interesting observations by the Chief Justice. He says PV Narasimha judgment results in a paradoxical situation where a legislator who accepts a bribe and votes accordingly is protected, whereas a legislator who, despite taking a bribe, votes independently is prosecuted. This paradoxical situation, it seems this has been ironed out.